The Wisconsin legislature has declared the policy that all meetings of state and local governmental bodies shall be publicly held in places reasonably accessible to members of the public and shall be open to all citizens at all times unless otherwise expressly provided by the law. The Open Meetings Law, along with the Open Records Law and the Ethics Statute, form the foundation for building the public's trust in local government. The actions taken by local officials and the way they go about their decision-making can have a profound effect on the level of public trust. Understanding and complying with not only the letter but the spirit of the Open Meetings Law will go a long way toward increasing the public's trust in local decision-making. The purpose of this video is to provide an overview of the Open Meetings Law for local elected and appointed officials. You will see that the Open Meeting Law is meant to ensure that advance public notice of a meeting is given, topics to be covered are specified in the public notice, and public access is allowed by limiting closed sessions and holding meetings in accessible locations. Before we get into the specifics of the law, let's talk about first who's covered by the Open Meetings Law. In general, the law applies to all state and local governmental bodies. Local governmental bodies, the subject of this video, include governmental bodies such as a county board, a city council, a village board, town board, and school board. In addition, the local governing bodies committees are covered, as well as the local units, commissions, and boards. For example, standing committees such as personnel, public safety, and public works committees are covered. Also, commissions and boards such as zoning boards or plan commissions and boards of review. These are all subject to the Open Meeting Law. The law covers local government ad hoc and special committees such as study committees or citizen advisory committees, and may include certain quasi-governmental and governmental corporations. Who's covered by the law? The law applies to all members of the local governmental body, whether those members are local officials, such as governing body members, sitting on the unit's committees, or citizen members appointed to a committee, board, or commission. All members of the local governmental body must follow the law. Both local members and public members are subject to a forfeiture penalty of $25 to $300 plus costs if they violate the law. This forfeiture is a personal liability and may not be reimbursed by the local governmental unit. Also, a court may void any action taken in violation of the Open Meetings Law, such as a vote taken on a matter not properly noticed. How is the law enforced? An action to enforce the law begins with a verified complaint by a citizen to the local district attorney. The DA then may begin a court action to enforce the law. If the DA does not enforce the law within 20 days, the complainant themselves may bring an action. In rare cases, the Attorney General may start an action to enforce the law. The following vignettes cover important aspects of the Open Meetings Law.